mention item 102, my lord. Item 102 today, my lord. Can it be taken tomorrow? My lords are having other matter also, my lord. So I'm just.
We are helpless.
I will be in person.
If matters which can be concluded within 1 hour, 1.5 hours,
Lord.
Matters are.
No, I'm in person. Otherwise, I would have not mentioned. I'm in person.
For hours.
So it can be taken
it becomes
tomorrow.
Very difficult. We'll try to find out a date. We could have taken it now, but ultimately we found that the 12 noon matter, which was fixed, Justice Massey and myself, we had heard it extensively. So that is why we put it at 2 now, so that does not have to start from scratch.
My lord, if it is,
we'll try to take it up, sir. We'll try to take it up.
No,
let us not waste time now. Let us try to finish it.
We had argued, I'm in that 11th for the Berozgar.
Berozgar.
Stain was appearing in the other matter,
so finally, what is the position today?
Position today is, my lord, what we had argued was that NCVT, that qualification was mandatory. We had demonstrated. It was for that brief period of 2014 when they amended the rules. Then it fell back again because of the central government imposed that this has to be the NCVT training. So that was the issue before your lordships. We had argued that this actually transgresses into a power which is occupied by the central government because they are the ones who really determine what has to be done. In the process, your lordships asked upon the state to see whether it can be done. There were some questions framed by your lordships by an order. The state has come up with 3-4 lists. To be fair to my my learned friend, the list produced insofar as Berozgar is concerned, lordship have 147 members. About 10 or 12 were called for interview. 10 names are missing from that list. But that's not the issue. The issue is if your lordships accept our first proposition that NCVT prescribed qualification is a must, CITS is a must, then this question of whether we qualify for the exam with coupled with the other people with us would actually fall by the wayside. So on the larger question of law, your lordships can decide, with utmost respect, my lords, that if the issue is decided on a point of law which we had argued, then, my lords, the list we had argued because we said there are quite a lot of vacancies still existing, if they can accommodate. The state seems to be a bit reticent on accepting the fact that they can take us in. Because 2014 was the advertisement which was subject matter of challenge. There was an interim order in our favor. So I had handed over a list of dates and notes of submission, my lords. Your lordship wants I can hand it over again and run through it if your lordship so desires. Or I can show the provision. I've shown one provision which is very startling. Lordship may kindly have my paper book, 15.2 or 23.2.
23.2.
2, hai na, Bharat?
Yes.
The other historical dates are all to be found in my note which I had given. I'll give you one more copy, my lords. What was mandatory earlier now becomes preferential. So at page 157, look at what is the way in which they have diluted the whole process. At 158, first of all, they say it's only preferential. Now look at what they do, Malas, 17.3, subclause 3 at 158. This is the notification under challenge. So the 3 says, the appointed persons will have to complete the CITS, POT and CCC courses referred to in column 5 of the appendix and obtain the requisite certificates at their own expense within 3 years from the date of joining, and leave shall be granted to them for the set period. If a person is unable to complete the same due to reasons beyond his control, he shall be allowed 1 more year to complete the course. Now, if a person is unable to obtain CITS so-and-so within the prescribed period, he shall not be allowed the first increment. So this training which is to be undertaken falls by the wayside, my lord. So you're giving a premium to such people who don't even have qualification. The only punishment is 1 increment. What was essential has now been diluted to be a preferential. Our whole plank of our argument before the High Court and before your lordship says that when the central government prescribes a certain qualification, and which was again later on restored by the subsequent communication by the central government, by GOs, cannot in this manner, Lordship will recall the degree diploma, those judgments, my lords, where some degree holders applied for the jobs and the rules did not permit. Judgment authored by Justice Ravindra Bhatt said that if the rules are amended, by that Uttarakhand amended the rules, so they said then it's another matter of challenge. But you cannot equate two unequal people to be in the same boat. That is our argument primarily.
That's all.
No, you from the entry now, entry trial, yes, 2075, and we can recover. Let's show me that. So, Lordship will be kind enough to take the note I had filed, my lords. I had handed over in the Want to give the note?
Yes, but the pages will be a little different, content is same.
Other side,
Give me one.
In fact, one attempt earlier was made in 2003. The High Court struck down, saying that this is mandatory. Lordship, can you run through my list of days, if your Lordship don't mind? The first is regarding Samiti Malak, then the prayer, and then read with line, fifth line from the second paragraph, Malak. Service rules are ultra virus rule 16.3.3, Article 14.16, Article 73, read with entries 65 and 66 of the Union list, and the central government order dated 24/7/96, as well being contrary to the binding judgments of so and so. Then, the National Craft Instructor Certificate awarded upon successful completion of CITS is issued by the National Council for Vocational Education and Training. To be eligible for the Craft Instructor Training Scheme, candidates must possess a National Trade Certificate (NTC), National Apprenticeship Certificate (NAC) diploma, or degree qualification in a relevant trade or engineering branch. Final year students of these qualifications are also eligible to apply for the program. Then that's at page 232. So the grounds that we had taken in the writ petition, Melo, extra copy there? Okay. So in the writ petition, Melo, we said it is contrary to the central government direction of 24/7/96. I'll hand over this, Melo, and make copies of the summation of what we had argued in the High Court.
Your writ petition is at 223.
Yes, Melo. 241 onwards, the grounds. I'll just get a Xerox because that's a summary in 2 pages, Melo, of the writ petition. So in short, the submission is this, my lords. The impugned advertisement 2 of 14 does not mention...
So, Mr. Mukherjee, one fundamental point.
Yes.
Where do you say that you have 134 members and this is being filed on behalf of 130?
The members list, my lords, annexure P1.
Where
that we had shown
where
in the
is
first.
P1 pleaded in the body of the petition?
In the writ petition?
In the writ petition?
Yes.
See, your writ petition starts at 227.
227, yes, my lords.
Right.
Yes, my lords. 223 at 227.
227 it starts.
Yes.
Where have you said about the association espousing the cause of 134? We find that 2 to 40 are individual members.
Yes.
They are covered, definitely. But where is your statement that it is also being filed for other members?
So that we have
Because
spouse cause on behalf of the association. It's mentioned registration also.
you mentioned the registration bit, my lords, at page 233. First, we kindly see this, para 9. That all the petitioner would be in the individual petitioners, after passing so-and-so and obtaining 2 years diploma, have passed training course popularly known as CTI, we're waiting for admission recruitment of instructors in terms of UP Industrial Training so-and-so, as amended by second amendment of 2003, which number 1 and 2 failed, and neglected since 2008 onwards, then also by getting registered under Society Registration Act, with registration number 1429 of 2010 individually, and collectively through the said society, named and styled as Berozgar so-and-so, with only CTI. Lord, can you notice only CTI pass as members earlier filed?
No. Where do we find that this is at the instance of 134? Today, in 2014, when you file it, you may have XYZ as members. After filing of the petition, there may be others. Where is that list?
Now, at the time of filing, those 134 is.
Where do we find that when you filed this writ petition,
I see.
sometime on 20th November 14,
Yes, sir, I understand.
there were 134 members.
Prior to that,
There is nothing stated.
No, that's nothing.
There is nothing stated about the number of members, not to speak of who are the members.
That's right. We just say that 2 to 40 are.
2 to
members.
40 are members, we can understand that. But about 41 to
I must concede,
134.
my lord, to be fair to the court, I must concede one point. While this matter was pending here, since the association was being represented, that respondent number 4 to 42 were deleted because they had not filed the vakalatnama. So, we kindly have that order. I must be fair to the court, my lord. I will.
You are respondent 4 to 42.
4 to 42, Lordship, order dated 4/5/23. Since the
4/5.
association was before Lordships,
4, 5.
23 minutes. So these are those individual writ petitioners in the writ petition.
Why would they be respondents?
No, they did not, at the time the association came here, they did not authorize the authorize the advocate in the court to file the vakalatnamas. And
At the risk of the petitioners, where they were deleted, but where is your statement in the petition that they were also your members?
in the,
Respondents 4 to 42,
yes,
they have been deleted, no doubt. Where is the statement that they were also your members?
para 9 is the only one.
No, para 9 doesn't help you. Para 9 doesn't help you. So if at all relief is to be granted, it has to be confined to 2 to 40.
That's right.
We cannot go beyond that.
I can make the statement across the bar, my lord.
No, it's not there. It's
No,
a
I know.
2000.
No. I'm saying if 2 to 40 is to be granted relief in whatever manner,
Right.
then I'll say I will not expand it, my lord.
Ah.
Today the membership might go up to 2,000. I do not know.
Only.
At the time of 134, I mean, this is also, well, it cannot be an endless sea. I understand that point, my lord. It cannot be that everybody jumping into the ocean and they start getting relief.
Right.
It has to be crystallized on the day of filing of the writ petition. To that extent, those members, private individuals, were there before the court in the same writ petition.
Right.
Lordship, we kindly have the cost title ones. At page 226, the last member, Akhilendra Pratap Singh.
Yes. We understand
Yes.
that. 2 to 40?
Yes.
Okay.
So that,
no
so we are-
problem.
I'll restrict it to that, my lord. I'll be.
Yes.
And then, इससे कॉपी दिए ना हाँ पीछे हाँ अभी compilation में है अभी तो compilation दो तो Lordship will have this the handout which I did. The comparison, my lords, will find at page 9, running page 9, of the 2003 rules and the 2014 which is impugned. The page 9 of this, the handout, my lords, the comparative table.
Yes.
So essential academic Lordship will have on the left-hand side of the column, must have intermediate 10 plus 2 from UP board or equivalent. On the 2014, it says must have high school 10th from UP board or equivalent lowered compared to 2003. Then next one is essential technical general instructors. Any one of the following: NTC from NCVT, National Apprenticeship Certificate NSC, diploma in relevant trade from Board of Technical Education UP, or government recognized institution for engineering, drawing and working calculate mandatory instructor training CITS or equivalent modules. I have underlined that, Manoj. Then when you look at the 2014 on the right hand side, divided into two streams, appendix specifies trade-wise. Stream 1 NTC stroke NSC holders, stream 2 diploma degree holders in relevant trade discipline. Then possession of instructor training CITS POT, qualification at entry is preferential. This is where the problem comes in. If not held within, must acquire within the prescribed period, which I showed rule 17.3. So therefore, there is a bonus given. If you don't do it, only one increment goes away. Then after that, this is not very relevant for our members, Manas. So if your lordship wants me to run, because I read all the list of this, so this is Manas, the substance. And there are
Apart
two
from this
judgments.
Berozgar, how many other individual writ petitioners are there?
40, that 40 up till item 40, it will be 39, I think. 233.
3.22?
227. Lordship will have page 227.
No, 23.4. There are 4 writ petitions.
No, I am for Berozgar is only.
No, Berozgar. Apart from Berozgar,
They challenge the subsequent advertisements.
who?
The other 23.1, 22. We also challenged the other one, but the others came in 2015 and 2016. Challenge was late. Your Lordship had noted that last time. We were the ones who had that.
So you are challenging the process of
2014.
14.
The subject notification or the amendment to the rules.
2014 process.
And there we had that interim injunction by the High Court. Interim, I mean, observation, I'll call it rather.
Right.
That it will abide by the result. Or selections made would abide by the result of the writ petition.
So in your case, the advertisement was issued
Yes,
on which date?
2 of 2014 is Manas. I'll just give you the date because the dates have changed here. ये तो पहले देना चाहिए था मेरे को. हाँ, 2014. Mandated. 7/11/2014 at page 6, my lords. Actually, my marked copy is page 6, 7/11/2014.
This was under challenge.
This was under challenge along with the rules, which was, we brought in the amendment on 31/2014. So both were a subject matter of challenge at page 4.
And then there was a subsequent advertisement, 23rd
15.
October 15.
Yes, madam.
23rd October 15.
15. And there was one also in 16, which I have not mentioned because I was not,
Because you are not concerned.
I'm not concerned.
So the other 3 writ petitions are concerning 15, 16 advertisements.
That's right. But so therefore your lordships had noted last time, I'm not arguing again to their prejudice. What I'm saying is everything was open-ended. Every argument was hinging on 2014. The other,
23, I have challenged 2014 as well as 2015.
Achha, in 23 there are 2 petitioners.
यहाँ पे उस ऑर्डर के अगेंस्ट नहीं है because in principle we were essential.
SLP 4012, 4013 and 4012.
Achha, these are three SLPs.
Yes.
In all, how many are there?
In 128.
Total 128.
Yes.
so there are 2, sorry.
128 petitioners in 3 SLPs.
Yes.
I must also say 2015 was also challenged by us.
Yes, this one. 23.1.
23.1.
23.1, there is only one SLP. How many petitioners?
One.
Petitioner.
Another 2 is there. Another 2, also 1 petitioner each.
What another 2?
23.3 and 23.4.
Wait, come one by one. 23.2,
That's me.
this is also Berozgar.
That's me.
That's you. 2240. 23.3,
Yes.
1.
1.
1 petition. And 23.4, 1. So, how many aspirants do we have? 1, 2, 39, 41, 42, 42, and 128. That means 180 in all.
Yes.
180? Yes, Mr. Singh, what do you have on merits?
Can I just cite 2 judgments or I'll keep it back?
You want to cite?
One is that Baharul Islam on that medical council. Where the
Citation.
Assam, I'll just give a lordship. Baharul Islam is 2023 SCC online,
2023 SCC online,
SC 79.
SC 79.
Baharul Islam versus Indian Medical Association. A little background, I was involved in that case. It's from para 69 onwards, where the Assam state government, Lordship will recall Bengal Medical Act also 1910. So they used to maintain separate registers. Now, they introduced a new course of 3.5 years, where they would get doctors, not doctors, but medically trained professionals to work in the North Karbi Anglong, specifically those areas where doctors refuse to go. So they said, we'll give you 3.5 years training within proper institute. And that was a 2005 new act, which was challenged by the Assam IMA, Indian Medical Association. The judgment by the High Court said that no, this is repugnant to the central statute. There was section 52, where the central government mandates everything. Therefore, NT 63, 73, everything was discussed in this judgment. And this court also upheld that contention that where it is occupied by the central government and instructions are given, the state government cannot tinker with it. That's the first proposition. And the Supreme Court also upheld that, though I argued for the petitioners there, that we are not doctors, we are not prescribed, we are not to take out major surgical operation procedure, not prescribe Schedule H drug or give injections like that. But the court did not accept our contention, but this is a judgment I'm relying on, Manas. Right. And so para 69 onwards. Then your lordships in that Anjuman Trust, it may be a bit far-fetched here, but your lordships emphasize on the necessity of having the requisite qualification.
That there are other...
That's a larger proposition, that's right. That may not be stricto sensu applicable here. So this was more on repugnancy. Though repugnancy was not exactly, we have said that this is, the state act is, in the instant case, is repugnant to the central government instruction.
Just 1 minute, Mr. Singh, let us get one clarification from the others. Acha.
Oh.
23.
Right.
Sir, you are appearing in 23?
Mr. Pathak.
Yes, fine.
Acha.
This same was
Very well, very well.
Yeah.
You have challenged which advertisement?
I have challenged advertisement number 2 of 2014,
2 of 2014,
dated 7/11/2014,
dated 7/11/2014,
and advertisement number 21 of 2015,
21 of 2015, dated
23rd October 2015.
23rd October 2015. You did not participate in any of the examinations?
We were not called, and some who were called, they were not given preference because we were having CITS.
One person has already been selected and is doing service. So pointed out to Lordship on the last date also.
Some called, some not called. Some not called, huh?
That time there was no written examination.
And when did you file your writ?
My lord, writ petitions were filed on 29/1/2015. Then another writ was filed on 4/10/2016.
4/10/16.
And then third one challenging 2015 advertisement was filed on 20th February 2017.
20th February 2007.
And as we have shown to your lordship on the previous occasion, that others were impleaded, their names are duly reflected in the memo of parties. Registry has amended the cause title, and those 128 are before the lordships.
So, very good. 23.1, Mr. Bhomik is there. You are challenging which advertisement?
23.1, my lord, I am challenging advertisement of 2014.
Also?
2014.
Yes.
Same advertisement.
Yes.
You did not apply pursuant to any further advertisement of 15/16.
No, no.
When did you file the writ?
Read petition file, my lord, on 29/9/2018.
29/9/2018.
Yes.
Your writ petition is part of the SLP?
Yes, yes. It's part of the.
Which paragraph you have explained the delay? 2014 advertisement you are challenging in 2018. Where have you explained the delay?
Separate. My SLP number. Read petition. Vinod.
Just find out and
Yes.
let us know. Next, 23.2 is Mr.
Yes.
Mukherjee's petition. 23.3,
23.3, madam.
under challenge is advertisement dated
23.3 is challenge. Vinod, my lord. sorry, my lord, 23.1, I should correct it. 23.1, I am challenging advertisement of 16. This is Maji. I'm sorry. I'm sorry. Just
You're challenging advertisement of 16.
16.
Nepali बताई दी इनको।
And in 23.3, I am challenging advertisement of 14.
Advertisement of 14.
Yes.
Very well. When did you file the writ?
And 23.1, writ was filed on 21/11/2017.
In 23.1.
Yes.
So it is
Reading and admin
21st November 2017.
Yes. Yes, ma'am.
And 23.3.
23.3, my lord, I filed writ petition on 29/9/2018, challenging 2014 advertisement.
So here the delay has to be explained. Where have you?
Yes, I'll. One petitioner, one candidate.
Yes, you have to give the
Then-
paragraph number.
I'll give that. And
And in 23.4,
23.4, my lord, I am challenging advertisement of 2015
2015,
and writ filed on 20th December 2016.
20th December 2016.
Single person.
Very well.
Not the query on which your lordships are immediately pondering over. There are three judgments on that. Right from 2024 and going back to 1975, which says it is well settled principles of law that where a citizen aggrieved by an action of the government department has approached the court and obtained a declaration of law in his or her favor, others similarly situated ought to be extended the benefit without the need for them to go to the. So there are three judgments, my lord. In my brief notes, I have.
Please.
I have mentioned
Just one
Yes.
last point, my lord. From the impugned order, page 49 onwards are the findings which I am seeking to challenge. So I'll give that one-page note. I'm just getting the Xerox done. Well,
Yes,
Lord,
Mr.
Lordship may very kindly have a short note that I have filed in the leading case, my lord,
Short note you have filed.
on 3rd November 2025, lord,
लिखा है ना?
in the leading files.
23 में.
So we should.
Like this.
It was the same one.
Already filed है.
इनमें बाउंड कापी इस तरह से बाउंड हो शॉर्ट नोट्स एंड सबमिशंस Lord Lordship may kindly have a few paragraphs of my note, my lord. On paragraph 2, Rule 7 of the Rules 2014 provides for the eligibility criteria. Rule 9A provides for mandatory qualification. With Rule 9B provides for preferential qualification, that is craft CITS, which is defined as Rule 3, means certificate awarded by National Council for Vocational Training. Rule 3, paragraph 3, Rule 16.3 provides for manner in which the merit list is to be prepared. Subclass A whereof lays down that based on the academic qualification, candidates will be granted marks on the following breakup. 50% of the percentage marks secured in the high school. That is, suppose the candidate has secured 50%, then 50% of that will be counted. And the others are also there, my lord. Then your lordship may very kindly have on the next page, paragraph 8, my lord. Pursuant to the impugned advertisement, oral interviews were held between January and June 2015, and thereafter the results were declared in October 2016. Successful candidates were appointed in November. Furthermore, all the selected candidates who did not possess CITS at the time of selection have since attained finality. And by amendment, it was said those did not possess, they can attain it, that they have attained it. In the above mentioned writ petition, there is no prayer for quashing the appointment orders, and accordingly, the selfies are liable to dismiss on this ground alone. The selfie is liable to dismiss also on the ground petitioners herein had participated in selection process initiated and completed according to impugned advertisement and the rules. Hence, they cannot challenge the advertisement and the rules after they fail to secure selection for appointment on basis of merit. Now, in the next I have quoted the rule. It has been held that having taken part in the process of selection with full knowledge that the recruitment was being made under the relevant rules, unsuccessful candidates had waived their rights to question the advertisement of their practice. This is lordship may kindly recollect Sarna Lucknow University, that on page 32, Malal. In subsequent judgment, it has been referred to. Paragraph 20, Malal, page 32. So lordship had pointed out this decision by B. Sarna University. G. Sarna versus University Lucknow. This court had held that appellant who knew about the composition of the selection committee and took a chance to be selected cannot thereafter question the constitution of selection committee. In Prakash so and so, then the quotation part, Malal, the petitioners also appeared at the oral interview conducted by the members concerned of the commission who interviewed the petitioners as well as the so and so respondent. The petitioners took chance to get themselves selected at the said oral interview only because they did not find themselves to have emerged successful as a result of their combined performance, both at written test and oral test, calculated chance to appear in interview only because so the process of interview was unfair and selection committee was not constituted. Om Prakash, so these are the decisions lordship had already pointed out. Then lordship may kindly have paragraph 11 also on by note, my lord. Page 3. In Srinivas so and so, it has been held that absence of any allegations of malafide or glaring error or perversity, the court cannot sit in appeal over the decision of the selection committee. Similar view was taken in so and so. The government had the power under the proviso to rule the constitution to make rules prescribing eligibility qualification as also prescribing preferential qualification. The proviso to rule 9B is an enabling provision for those candidates who did not have the preferential qualification at the time of notification of advertisement to acquire the qualification within the prescribed period of 3 years, as laid down in Rule 17.3. The argument that the proviso to Rule 17B is violative of Article 14.16 is untenable. It cannot be said that proviso was intended to recruit non-meritorious candidates. The recruited candidates who did not have the preferential qualification can acquire the same within a period of 3 years. It does not in any manner affect 16.3, which lays down the manner of preparation of the merit list. Furthermore, the petitioners, in spite of having benefit extra 15% marks, percent marks for possessing preferential qualification, were still unable to secure. Now, these are the decisions. Then I have submitted a chart, my lord. Various charts pursuant to lordship direction. The first chart was filed on 19/11/2025, my lord.
First one, this is the first one.
Yes.
Irrelevant has chart. Chart 1, my lord, lordship will kindly see.
Petitions and date.
Writ petition SLP number, and then column 2 writ petition number, then filing date, writ petition, then number of petitioners before the Honorable High Court as in the memo of parties in SLP status report so and so. Then advertisement number is also mentioned by the last column, which they have challenged. Advertisement number 2 of 14, then 16, 2 of 14, my lord, then
They were telling from this chart only, Your Lordship. When they got.
No, Acha, Mr. Sen, your friend said that there are in all 128 in 3.
We are concerned.
But Mr. Singh's chart show that there are 2, 3 and 1 in the 3 petition. You had filed application for addition of party.
When SLP was filed, they had application seeking impeachment.
we were not in the High Court. High Court mein nahi the.
No, these extra parties who have joined as petitioners, were they petitioners before the High Court?
Different writ petition.
Some of them are have been implemented afresh.
No, if you were parties in other writ petitions and your other petitions were dismissed, how could you have joined in somebody else's petition?
Although this question arose when I argued this application.
Right. So you have to give a legal answer. Just because the bench has allowed the application for impleadment will not help. You are a party to another writ petition. That writ petition is dismissed by a judgment. That judgment is not under challenge by you directly. Somebody else comes out with a SLP against a common judgment, and then you come and seek your impleadment.
Same question of law.
Maybe you show us one precedent that this is a permissible course of action. Mr. Sen, you will have to satisfy on this. That apart from these 6, those who have been impleaded,
Yes.
they can at all maintain this appeal.
And my lord, they are entitled to relief. Let my learned friend.
Entitlement to relief comes after you satisfy us on the entitlement to be there in the array of parties.
In fact, I have taken one of the points in my written statement that those who have not filed, they cannot challenge in this.
Right? They have
That
to
is
challenge
paragraph-
their own order. Otherwise, there will be no impleadment.
That judgment and order in so far as this petition SLP has not been filed, attained finality would operate the res judicata, and that decision is also noted in paragraph 13 of my note, my lord.
Paragraph 14 of your note.
Note, my lord, that is 13(1)(3). Decision is 2015-3 SCC 634.
Total 43.
Issue was common in all the writ petitions.
Yes.
Now, Lordship may also have chart number 2 pursuant to Lordship there. Page 4, my Lord, I'm sorry. इसमें क्या है? Regarding the interview, interview held, my Lord, advertisement number 2, I've given the details of all that.
Where is chart number 2 starts at page?
Page 4, my Lord.
Page 4.
First chart. Second.
Chart number 2.
Date of interview, third column, my Lord, so and so, dates gaya. Candidate, number of candidates, 7,787. Interview. Cutoff lists are annexed 3 to 4. Regarding the status of different recruitment advertisement, blood, I have given all these details.
The number of posts advertised, date of interview,
For example, number 2 of the number of posts, 2,498.
But Mr. Singh,
My Lord.
if the number of candidates who have joined is around 700 less than the number of posts advertised.
उसे forward हो गए या 2022 में advertisement हो गया.
Huh?
Those unlift vacancies, they have been carried forward in another advertisement.
No. Why? You are saying that the selection is based on marks which
merit.
they obtain for their academic qualification and 100 marks for interview, which is reduced to 15.
My Lord.
Out of 15, how much?
My Lord.
So what is your cutoff? Where have you said about the cutoff? Because all these people,
Next chart.
Chart 3, page 6.
page 6,
Grade-wise minimum cutoff merit percentage. ये सबका detail
no, this hardly answers our query.
My Lord.
You have appointed 1,700. We are concerned with 2014 notification.
My Lord.
You have appointed 13 candidates. The number of vacancy was 2498. That means 785 posts were not filled up.
The reason I have given in column number, last column, 585 candidates did not join.
Number of candidates who have joined is 1713
Okay, 1713 comparative.
out of 2498. You are showing us from this chart at page 6.
Number of candidates joined 1713.
Where, did you prescribe that, say, the entire process is carrying 100 marks and everyone has to obtain minimum 40 marks?
That was the equivalent on the basis of merit, entire merit under Rule 17. That I have.
Where is that stipulation that one has to obtain 40 marks for becoming eligible? If it is not there, you cannot just stop at 52% for general candidate. Why will you not go down?
Rule 16.3 provides the manner in which the merit is to be prepared.
Let us see 16.3 once again.
156 is 157.
On my
156, 157.
no, paragraph 3 of my written
Sir, given there.
written note, madam. Paragraph 3 I have noted it.
Something-
Page 1 of my written note. Rule 16.3 provides the manner in which the merit list is to be prepared. Subclause A, whereof lays down the best academic qualification, candidates will be granted marks in the following breakup. This breakup where then the next page, my lord, also will find a list of candidates is prepared under Rule 16.3, whereafter interviews accompanied with 100 marks and 15% of marks obtained in the interview are added. Each candidate, a
Where
final
do you say that this is the minimum mark one has to obtain?
minimum mark.
we selected that. We did not
There is no cutoff. You simply stop at 52. You say last general candidate has obtained 52 marks. You stop at 52. Why will you not go down if there are vacancies?
No, selected
Please clarify.
minimum
157, my paper book.
57 of 23.2.
Yes, ma'am. 157.
minimum cutoff.
Yes, 157.
3, clause 3. Second one.
Clause 3.
Yes. In making selection for direct recruitment, the merit list for the eligible candidates shall be prepared in the following manner. For academic qualifications prescribed for the post, the marks shall be awarded to each candidate in the following manner. 50% of the percent of marks secured in the high school examination shall be given to each candidate. 20% of the percentage of marks secured in NTC test shall be given to each candidate. Then, or 20% of the percentage of marks secured in diploma degree examination shall be given to each candidate. Then 15% of the percentage of marks secured CITS stroke POT test shall be given to each candidate. After the results of the evaluation under clause A has been received and tabulated, the selection committee shall hold an interview. So there is no cutoff.
Now, this is what I have stated.
Which we had argued.
So there is no cutoff.
I followed.
So if there is no cutoff and you have vacancies, why will you not offer them appointment? You can't say that you have not crossed the cutoff mark. The only defense would be there was a cutoff mark, you have not qualified, therefore we have not appointed. Now today, if for the general category, say let us say 100 is the total marks, somebody who has obtained 52, you followed it.
Question is this, my lord, that final score based on which final select list is prepared. Chart. Cut off mark on Lordship में कल on page 144.
144.
Four of the
Of the first petition.
144 of the first petition.
What we want to place before your lordship is rule 16 of the 2014 rules. Wherever your lordship wants to.
100. Yes, we were reading from 23.2. Please, very well.
16.
Yes, we have read it. 16.4.
16.4.3, my lord. Then B, Roman 1.
Yes.
My lord, after the result of the evaluations under clause A, which is what your lordship has seen, 12th marks, so on and so forth.
We have read it.
Received.
Mr. Singh, please come to page 4 of your chart 2. Page 4 of chart 2.
yes, my lord. Cut off list.
Number of post is 2498.
My lord.
Third column. Sixth column, number of offer letter issued is 2298.
2298, yes.
Right? So, how many remain? 200 posts, you have not issued any offer letter.
Left out, kindly see the next column, my lord.
No, forget about not joined.
No, not joint.
Number of candidates joined, not joined, we are least concerned for the present.
Lordship may have the top of the.
No, not top, bottom. You please explain. When you have 2498 vacancies, you have recommended for appointment 2298. That means straight away there is no recommendation for 200. Now, how do you stop at either 50 or 45?
The reason is given on the last column, my lord. Reason, Lordship is under the head lead reason. 585 candidates did not join. Next. 70 seats vacant due to unavailability of eligible candidates in various trade categories.
How do you come to that conclusion? How do you come to that conclusion?
In the first column, under serial number 2, when your lordship sees the second column, number of candidates called for interview, 10,000 in the first round. So depending on, my lord, different trades, four times the number of eligible candidates for that particular trade had to be called.
Right.
That is how, my lord, out of.
So they must have been called because they have their certificates.
My lord, 10,000 people in the first.
10,000 after shortlisting of 7787. How do you come to the shortlisting part? It has to be based on academic qualification and that professional qualification. So if you don't include arbitrarily within 7787.
Under 16.3B.
No, how do you? They are getting extra 15 marks. Remember that.
My lord, the result is after factoring that in.
Anyway.
Just read, my lord.
Mr. Singh, we are giving one suggestion. We have been hearing groundwater matter.
Something's come back to haunt me, my lord. This is the first objection.
Groundwater lordship is
Look here,
finished.
there were vacancies. We feel prima facie
Yes.
that they may have been. We will not use arbitrarily or illegally. They may have been inadvertently omitted from the zone of consideration. Without even asking them, we are putting it to your state government. Appointment has to be given to them. They will not get any benefit. They will not be entitled to counting of this 10 years for their retirement benefit. Take instruction whether you are willing to give them or not.
Very well. Lordship may have.
And let us also say the other thing. Suppose we are in their favor. Then not only will they be entitled to appointment, we may also direct other things to be given, which could be difficult for your government.
Very kindly give us 4 weeks at least, madam, so that.
4 weeks would be too much, otherwise we will forget everything. We are not touching the private respondents, they are working, their seniority will not be disturbed, let them work. But at least these persons, they are not too many.
2 हफ्ता कर दें अगर.
No, after Holi.
Holi.
After Holi, 1 week after Holi we will keep.
That will.
Right.
That will do, madam.
Or should have used Mita Sahai for that other proposition.
Are-
No, I mean on the other. So
That is why we have said we will not give you anything
No,
other than the appointment.
whatever falls on my lordship, we are not bargaining here.
And only Mr. Sen,
My lord.
you will have to satisfy us that these other persons who were included without filing appeals independently, they are also entitled. Otherwise, the figure is very small, 40, 39, 645 and another 4 or 5.
My lord. Any date after Holi, my lord.
Yes, we'll keep it.
1 week after.
कब बैठ रहे हैं हम लोग? of March at 3:50. 12th of March at 3:50.
May I just take back that note, add 2 pages and index
Very
it,
well.
my lord. I'll just do it. My advocate record will do it.
No, you give a fresh note.
No, it is just addition.
No, addition because
No, I'll make the handwritten index. It's complete.
no,
I'll go.
it has my notes.
Oh, I see. Oh, sorry. I hope positive.
Never know.
Very well.
Last ball is gold.
Can you log 19th March?
19th March at 3:50.
Sir, 12th March.
Well,
What?
12th March.
क्या March? Oh, sorry. 12th March, not 19th.
12th March. ठीक है.
12th March. 12th March at 3:50.
350.
In the other matter, I believe your lordship's called for. I was not here, so I could not. Your lordship. My bad luck, my lord.
Whatever you want, put it in your written note.
Very well.
We'll consider.
File along with the note.
Chal.
My lords, I wanted to make